Hello, this is the meeting of the Regulation Subcommittee of the California Paraprofessional Program Working Group. I'd like to start by calling roll. Hartston.
Here.
Sarouche.
Here. Hi, everybody.
Hi, so we're all here. We can get started. We want to start with public comment. Should just give people a minute or two to join the meeting since we just started it. And at the last meeting we had a little while ago, a meeting of the Discipline Subcommittee, and there were people, we had public comment partway into the meeting just because I think some people joined after the very beginning. We can see if there's anyone in the public who's attending who would like to make public comment, please raise your hand using that function in Zoom. And otherwise, we'll get started. It doesn't look at this point that we have public comment. So I hope everyone saw, I posted the draft language that Amos provided for having to do with fees. I posted it this morning just because if we're going to discuss it, I thought we should make that accessible to the public for review. So if there are any members of the public who haven't seen that, if you go to the agenda for this page, we added a document this morning, although if you haven't received the notice of this meeting, I imagine you received the notice that the materials were added. And I'm not sure if we want to start by talking about where we are, because the next step is going to be drafting the memo. And thank you, Amos, for starting that work and developing that language. And I can build the memo around that, but that will really give us a good start. But so far, it looks like we've got the preliminary recommendations for continuing for financial responsibility. And I think that we're settled on that, including sort of the questions that are still outstanding that we want to bring to the working group as a whole to get some input. I have that on the next, I believe I have it on the next page. And that's where we left with that.
So I think that's right for financial responsibility, except for the bond amount. I don't think we've talked about that. And I think it makes sense for us to spend a little bit of time to see if we can come up with a joint recommendation on that.
Sorry.
And I thought you said that intentional acts aren't covered. So I have a note that says bond covers fraud, but not intentional acts. So
isn't fraud an intentional act?
But not other intentional acts. So I may have taken a note. Amos, do you know? Do you remember?
Well, generally with bonds, I don't remember if this was covered in the presentation, but generally bonds don't have exclusions. So it's basically for financial responsibility. If the professional is responsible for something in their performance of duty. So there's usually, I don't think there's usually a fraud or intentional act exception.
Like I said, I have this note as part of the rest of my notes. Could we, I could have taken it wrong. He may have said fraud and other intentional acts, and I put, but not other intentional acts, but perhaps we can ask for clarification.
Yeah, my understanding also was that there weren't, I thought that was specifically said that the bonds don't have exclusions. I think we did ask about that.
Okay. I'm willing to go with what the majority heard. And it seems like you have more experience with bonds than I do, so totally okay with that. So why is there a question mark there then?
This is, I haven't had a chance to update.
Oh, got it. Okay, got it.
PowerPoint since last time.
Okay.
In the details. So
I agree we should talk about the amount. I don't recall, I had the question of how come there was 100,000 for example for immigration consultants, but only 15,000 for notary bonds. And then there was some discussion about, was there any discussion about the reasoning? Do you remember?
The one thing that I think was in response to your question was that it was clarified that this is a total amount. It's not a per claim. So if one person came with a $15,000 claim and another person came with a $10,000 claim, if the bond is limited to 15,000, it's first come, first serve until the bond amount is done. It's not a per claim. But beyond that, I mean, I can tell you from my personal experience that there have been a lot of concerns by advocacy groups about immigration consultants and, you know, in terms of quality of services and fraud and other issues. And so I don't know the history of the bond amount, but I wouldn't be surprised if there was, you know, the real concern for consumer protection in that space in particular, which would require, you know, increasing the bond amount.
The concern is that it's not enough 100,000 is not enough, especially when there are multiple claims.
Well, right, and $100,000 is a very large bond. So what I'm saying is I wouldn't be surprised if that started out lower and over the years had increased because of problems. I'm just guessing. You know, the notaries are 15,000, legal document assistants are 25,000. They do not provide legal advice. So, you know, I imagine the stakes will be higher with paraprofessionals that we're talking about, but $100,000, we also talked about some concerns for entry and, you know, with a larger bond amount, there might need to be background checks or credit checks. So I think you mentioned might be a good thing, but we also have to, you know, balance between the burden on the paraprofessional and barriers to entry to the profession and consumer protection. So, I mean, I think those are our, you know, bookends, right? 25,000, probably on the low side for this. I think probably both of us would think something higher than that. Might be hard to go higher than 100,000, you know, although, you know, the more there is, the more consumer protection there is, but we have to balance that. So I don't know if you had something in mind.
I think at one point we talked about 25,000 because for civil cases there was a discussion about paraprofessionals being limited to limited jurisdiction cases.
Yeah, I think that's right. I don't think I'm on that debt, consumer debt, and I think hasn't been decided, but I think that is one of the limitations that's being considered. Again, that would be for a single claim. So a single claim could be as big as $25,000, but that's something to take into consideration. I think there's going to be some limitations on the size of the cases at issue, at least in some of the practice areas. I don't know how that works in family law.
What about the eviction people, the eviction subcommittee?
I don't think they've met yet.
Oh, they haven't met yet. Okay, I was just wondering. Yeah, as far as the cost, I believe for the $100,000 bond was something between $1,200 to $1,700 for 2 years, and the range is dependent on the background investigation and credit report, which is when they brought up the access issue. And
right, and the $25,000 was much lower and did not seem
$35 for 2 years for the $15,000 one for notaries. I didn't take a note about the $25,000. So
it might be a little bit more expensive because this professional will be doing more things, yes. I think, and, you know, potentially have a higher risk, right? So we don't know exactly what it would cost, but I would think that's the range. Is you know, it may end up costing a little bit more than what LDAs currently charge, but I don't. So did you have something in mind, sort of to anchor the discussion?
I'm just, again, gonna anchor myself at requiring 100,000 for immigration consultants, which is sort of closest to where we are. Although I'm not familiar with whether immigration consultants can give legal advice, which they can, because right now that would be unauthorized practice of law, but the forms are sort of complicated. Can they prepare forms that points and authorities in support of, an asylum application or something?
So I will tell you that there's two answers to that. The right answer is they're not supposed to provide legal advice, right? Because
Yeah,
they're not authorized to practice law, and there are criminal cases of unauthorized practice of law. In reality, they're doing it all the time, and this is part of the issue, and maybe part of the benefit of this program is that we'll have licensed, trained professionals
yeah,
providing services. Although right now we're not talking about in the immigration space, but yeah, I think that's the problem, is you have a lot of people who aren't necessarily trained and aren't licensed, and so that's why the increase. I mean, $100,000 I think would be great consumer protection. The only thing is, I suspect there may be a barrier to entry to the profession and a burden related to that for the cost. But I think we're in the right place. So maybe we, I don't know if there's a way, Linda, to find out if we're going to put it up for discussion of the full working group. If we're deciding between 100,000, 75,000, 50,000, and if we had an idea of, I think a big issue will be what's the cost, or what's the expected cost, because the higher the amount of a bond, the more consumer protection, but we have to balance that against something, and we probably need a little bit more information about what type of barrier to entry that would be, what type of cost that would be, and it might even bleed into the malpractice or restitution fund discussion, because the higher the bond is, maybe the less need for something else. So I would be very comfortable with, $100,000 bond, but I also think if it's too expensive, we might need to consider a 75,000 bond or
So
50,000.
for some of the same reasons, I feel like I'm flying blind here. I would want to know what the discussions were around selecting 100,000 for, or the bond amounts for the different legally related professionals that we already have. That would help me out. Also, on the other hand, are we discussing the kind of cases that under each different specializations, these new professionals, licensed professionals are allowed to take, and the type of damage they could cause, right? So Linda just mentioned limited civil cases. Yeah, okay, the claim is limited to a certain amount, but that's per claim. Okay, what kind of discussion goes through that? In a family law case, it's not always monetary. The loss that they could cause someone is not always monetary. If they get a negative result from a custody visitation hearing because directly related to the fault of the paraprofessional, how do you measure the damage? It's not always that. Or if child support could have been reduced by $100, but it was reduced by $50, okay, you could possibly measure that. So I'm a little bit, I feel like I need a little more guidance, and I want the maximum consumer protection. I think $100,000 sounds great, but I can't rationalize it if it's cost prohibitive, if it's also the cost is related to credit reports, and we know that persons, low-income professionals or persons of ethnic minorities, for example, are, don't have credit, or younger professionals we discussed, they don't always have credit because they just haven't done enough. How do we get around that?
So great. I actually think we could do a joint proposal on this. At $100,000 makes sense, but maybe we can collect a little bit more information, and maybe we have to consider instead an alternative of $75,000 bond if the $100,000 is too expensive or cost prohibitive, and $75,000 would make a significant difference. It sounded like there may be some cutoff like that where credit checks are required, or more, more underwriting goes into the bond. That doesn't happen at 25,000. That does happen at 100,000, but I don't know where the cutoff is. So I think we could draw up a joint recommendation and put this for discussion, but I agree Fariba, that we probably need a little bit more information about the cost and the underwriting of, for example, what a $75,000 bond would be compared to 100,000. Is that something you think is doable, Linda? I don't know if that means we could just maybe collect that offline and put it in the report. And
I don't know. I don't know that I don't think that we're going to be able to collect all that information in time to include it in the report. We're aiming to get the reports posted on Friday. And the thing is, in terms of determining the amount of the bond, there are different ways it's done. Like, there's not any licensing board that regulates immigration consultants. So to figure out the process for how that $100,000 was determined, it might have just been a legislative process.
I can find that out. I can look into that. And
I had a long conversation with someone from the contractors licensing board. The 15,000, I think that's a $15,000 bond requirement for licensed contractors. They were directed by the legislature to do a study. It took quite a long time to do the study to find out, how effective that is, if it's sufficient, a sufficient bond amount, and they're going to be proposing a recommendation to increase that. I don't think that there's one. I think each licensing board determines what the bond amount should be. So, we can begin some investigation, but I don't think it'll be ready. This could be something where that's sort of a, that this subcommittee is going to continue to do work and is seeking input from the full working group.
yeah, I think that's great. And I think we should get public comment on that as well. But I'm happy to find out, Fariba, if it's helpful, the background on the immigration consultant.
Yeah, I just
bond.
Googled it and a lot of information popped up. It's
Yeah.
available on the Secretary of State website. So I'm sure that we can get more information that we have right now. So for discussion.
The other consideration is, beyond just the credit check and the amount of the bond, one of the things that we were told at the last meeting is that there is underwriting involved for bonds, typically over 25,000. And if someone is unable to secure a bond, then that bars them from entry into this licensure. And so then you end up having these surety companies, in some ways, controlling who gets licensed and who doesn't. And that was a concern that was raised during the malpractice insurance working group, that they didn't want insurance companies to decide who can be licensed to practice law. So this is something somewhat similar. So I think that should be a consideration.
I definitely agree. And that's why I don't know if there's a cutoff, if that's just a 25,000. I do think $25,000 is not enough. And so if the cutoff is $25,000, I think we're going to have to live with that. But there may be a cutoff for underwriting that's, between 50,000 or 75,000. Clearly at 100,000, we've heard that underwriting is a issue. Again, it's good and bad, but it is an issue that we need to consider. So that's one of the things I want to know. Like, if it's a 50,000 bond, is that issue materially different than a $100,000 bond or not? I just don't know. So the other thing we heard, I think, is that there might be different, I don't know if it's types of bonds or maybe it's just regulations of professions, where if a claim is paid, so it reduces the bond amount effectively. Let's say there's a 100,000 bond and $30,000 is paid out on a claim, so there's $70,000 left. I guess there's different ways to handle that. Either we ignore that and they have their bond and it's just being used, or we require it to be reimbursed or reset. And I think that, again, is something that our committee needs to think about and make a recommendation about.
And I think they talked about how if the bond amount of the bond is paid out to a claim, the person can't practice until time comes for renewal of their license, where they can get another one. Like they can't get another bond until it comes time to renew their license. I thought that's what I heard. That they cannot when they pay a claim, they don't allow the licensed professional to get another bond in order to able to practice the remainder of their licensure?
So I think we have a choice between different schemes. One is, at the beginning of the reporting period, they report that they have a bond, and then we don't check. They have that bond, they're licensed, then we'll ask them again next renewal period, which we have to decide at that 1 year, 2 years, 3 years, or whatever it is. And then if the paid out claims doesn't affect them, they're able to keep practicing. If we want to limit the ability to practice under the license to having a full bond, we would have to think about that and decide that, because I think we'd have to have a specific regulation that says you need to reimburse the bond. I think the way it works is if the professional reimburses the surety company, then the bond is back in for its full amount. And so we could, not renew a license unless they had the full amount. We could, or, constantly be checking, or again, a hands-off approach is we just check every year on X date, you have to have a bond in this amount. So I think that's up to us. And I think the notary person explained that there are different states do different things for notaries.
And it sounds like high maintenance for the state bar if they're to continually monitor. If the paraprofessional loses a claim in the middle of the period, okay, the question is, do we want to let them continue to do work at the risk of, hurting other or doing bad work for other people, or do we want them, continuously monitor? And if they lose a claim, they have, like you said, they have to show that they can bring the amount up or stop practicing.
Yeah, I mean, probably the lowest maintenance would be just a annual check or an annual confirmation that they have a bond amount in the required amount. And if they don't, they need to get it, back up. Probably the easiest for the bar and would have sufficient protection that, because otherwise if you just check a box that you have a bond at the beginning and it's never checked and there's no, check-in, then, that the bond might lapse or there might claims be paid out and not much left. So probably some sort of annual certification or something like that. And
these guys do every 2 years, it looks like, for immigration consultants and notary. And I do, again, that's another option is, do we want to make it annual? Do we make it, every 2 years? What's the happy balance there? Considering everybody, the consumer, the professional, and the state bar.
Linda, do you think the bar has a preference for how that is administered?
I don't know that the bar would have a preference. And I think we would definitely want the court to weigh in on that. In terms of whether someone has a bond or not, and whether it's currently valid, my understanding from what they told us last time is that the bond, as the differentiation, one of the differentiations between malpractice insurance and a bond is that the bond, the state is the obligee, and it's public information, and anyone can go look at any time to see the status of someone's bond.
True.
And so if that's the case, I think the state bar can't put out there that all these people are bonded to a certain amount if someone could then independently look up and see what the bond status is of someone that they're planning to hire and find out that it's not the full amount.
So I think
we were talking about, I thought Amos was talking about licensing, that every year they have to submit a declaration under penalty of perjury that, yes, I meet these qualifications for my license to be renewed. Isn't that what you were talking? And one of them being bond requirement.
Exactly. So just as an example, let's say somebody has a bond and it lapses. They don't pay their premium or whatever it is. Or somebody has a bond, but claims are paid out. So it's half the amount that's required. The question is, what, if anything, happens to their ability to practice under their license? Nothing happens unless we create some regulation that says something happens.
But again, my concern would be if there's not a consequence. So someone has claimed, and there's not the issue of premiums because you pay it once and it's good for 2 years. So it doesn't happen the way that happens with insurance. Where the bond becomes less than the full amount is if claims are paid out. And what I'm saying is if one of the things that the state bar says when someone goes to look up about paraprofessional, and it says they're required to have met these and these and these, educational requirements, testing, and they're also required to have a bond in this amount. And the state bar puts that on our website. All paraprofessionals who are licensed have a bond in this amount. And the person the consumer independently goes and looks up a paraprofessional and finds out they don't have a bond in that $100,000 amount. They're going to say to the state bar, look, you've promised that these people have in order to have a valid license, they have a bond in this amount. And now I'm finding out that they don't, then the state bar's information becomes unreliable.
Right, although I think that when you look up the bond, they would have the amount of the bond. So the amount of the bond is the amount that the surety company guarantees. So let's say it's 100,000. That stays 100,000 even when claims are paid out. It's just that there's not the full amount left.
Okay.
So I don't think there's an inconsistency issue, but I do think there's a license issue. In other words, do we have a regulation that says they have to get that policy back up to the full amount or something? So again, I don't know that we have to recreate the rule. We could do what other license boards do in this situation, but it sounded like we might have a couple options. I can look through that and circulate something, again, some draft language or proposal for us to consider. But again, I think we're on the same page, at least for our report to the full working group, sufficient to have a discussion about financial responsibility, I think.
I think so too.
Okay.
It looks like we have a hand raised. I don't know. Do we want to try?
So then do we want to turn to public comment now?
Yeah, let's do that. If you don't mind.
No, that's fine. So I see we have one person for public comment, and if anyone else wants to. So I'll start with Julie Felmuth. So Julie.
Hi, this is Julie Felmuth. I don't mean to interrupt, and I haven't been part of this discussion. I just wanted to give you some more information about the way the Contractors Board does it, at least as of about 10 years ago. Can you hear me?
Yes.
Okay, thank you. The Contractors Board has some sort of an electronic hookup with all of the various surety companies that sell contractors' bonds in California. And they run a check like once a week or once a month or something like that. And if you look up a contractor on the Contractor State License Board's website, you will see the actual company that has issued the bond, the amount of the bond, and you can actually look back, several 10, 12 years to see if that contractor had a bond in all those years. So there are ways to do this electronically where the bar would be getting this information directly from the insurance companies and not just based on somebody's declaration under penalty of perjury, where that may or may not be true and may or may not lapse. So I just wanted to give you that piece of information.
Thank you. Is there anyone else who wanted to make any comment? Any other members of the public? If so, you can raise your hand. Okay. Oh, it looks like we do have someone. Angela Grijalva.
Hello, can you hear me?
Yes.
Okay, perfect, thank you. So listen, forgive me if y'all have already discussed this, but I guess I wanted to find out what the benefit of having both a bond requirement and insurance or malpractice or E&O requirements. I mean, wouldn't the public get coverage under both? And I'm just thinking about just making sure the idea of this is making the profession, what I guess not cost prohibitive to going into, and then, you know, the cost does roll downhill, if you will.
No, thank you for that question, and I think we're going to discuss that more. I think we are have been struggling with that. We want to have some financial responsibility, and we've been talking through the three things that are on the chart that's being shared right now. And, you know, I think we've been switching back and forth between proposing bonds and malpractice insurance or both. And I don't know that we have a, you know, I think we have a joint recommendation, but I think it's going to be interesting. I think people are more familiar with malpractice insurance, but malpractice insurance isn't required for attorneys. And licensed professionals often are required to have bonds in the state of California. And so other people besides attorneys are very familiar and comfortable with bonds. So yeah, I think we're trying to balance public protection and barriers to entry and costs. So very, very helpful. And I think we're going to be struggling with that, and we have more opportunities for public comment. So I think we're done with financial responsibility. I think we know where we are for our report. I don't know, Linda, do you want to move on to something else?
Yes. Let's see. So the next thing was the continuing education. I think we've come up with that recommendation.
Sorry, one thing on continuing education. I don't know if you are familiar with what the licensing subcommittee is doing with training. I don't know if that all has to be live training or there's going to be courses, whereas this continuing education is going to be different because it might be a webinar or something like this. I've looked around at some MCLE requirements for different things, and it seems like there's sometimes some discussion of, you know, how much can be self-study or how much is live or how much. So I don't know that we've talked through that. I don't know if there's something standard that applies to attorneys that we should incorporate, or if we should be specifying that more. Just something for discussion.
And so the attorney MCLE, there's a certain a number of hours that have to be, I don't remember the exact language, but I think it has to be active participation. So, and I think that can include online courses, but it doesn't include self-study. So I think that's a
The rule is that no more than 12 and a half of the 25 credits can be self-study.
And in
So
the, oops, sorry, go ahead, Emma.
No, go ahead.
No, I'm going to talk about something else if you want to.
So I think we should probably have some, I don't feel strongly about what it is, but I think we should clarify and probably something similar to what's done for attorneys. I think, you know, in other words, it can't all be self-study hours. There needs to be some live courses or interactive courses or some kind of, you know, I'm hoping that law schools or maybe the bar or others will come up with, you know, trainings that really dig in on the issues. And so, you know, I have that in mind, but I just think if we're doing the regulation, we might want to clarify, you know, what is meant here.
Do you want to do it similar to attorneys where no more than half, basically? So it's half of the total amount for attorneys. So it could be no more than 18 hours of self-study, or do you want to have the self-study be less than that?
I would just follow the same guidelines.
So do you know if the specialist guidelines have a similar requirement? That's sort of what we tracked. I'd be comfortable with no more than 12 hours of self-study. I think more than 12 is pushing it. I think a lot of this, the majority of it should be interactive or live or something like that. Webinars count as which? Webinars are,
I think that's considered, I think it's the self-study only that has a limitation. Yeah. I think the modality, whether it's in person or remote, is not affected. It's just this, whether you're actively engaged.
Right.
Yeah, so I think less self-study. So, or similar to the attorneys, like no more than 12 hours of self-study is where I would start the bidding.
But I would repeat the question of, is it the same with specialization credits that is half?
I'm trying to look for that right now.
Okay,
I don't think the specialization credits have limitations from when I reviewed it.
But
so then that would mean,
I'm not 100% sure. You're looking into that, Greg?
yeah, I'm looking.
okay, so let's wait. What I wanted to add while we're waiting is that in the family law subcommittee, we may be recommending additional units of CLE for those who select the violence prevention specialization. This is being discussed, but I'm expecting that will happen. So, again, this is a living document, and there's going to be changes to this part of it as well.
So just to be clear, that's very helpful to know, and I'm not surprised. That does make sense to me. I think the way we've segregated this, that's to get the initial license. And so what we're looking at is to maintain the license
Right.
after they have it. So the
Yeah.
question would be, and I would defer to the practice area group, but do they not only want it in the initial licensing, but do they want additional or different or specified training for continuing the license over time? We, just so you know, Fariba, in our draft language that I think we're going to go over again, we have a placeholder for that. I think we've left it up to the licensing, the paraprofessional board to require specialized training. But, I think we should start with what we want, right? So if there's specialized training that's required, we should consider if that should be continuing as well.
Right, because we are going by specialization now, licensing, they have to choose their specialization. I think there needs to be, that would be my opinion, not only for family law, but I really do think, for example, UD, I mean, there's so much new law right now for UD. It is temporary due to COVID-19, but hey, whatever the circumstances are at the time we create this new licensure or licensing process, there's each specialization, we should look at whether each specialization should have its own annual CLE.
Right. So just to be clear, so if you look at the chart that's up,
Yeah.
of our recommendation of 36 hours every year, there's ethics and competence and elimination of bias, but 30 hours are in their practice area. And the question is, does anything need to be more clearly specified or identified by practice area? Because there might be like a domestic violence training, or there might be child custody training, as opposed to letting them do anything in the practice area. And again, 36 hours might not be enough. Some practice areas might say, you also, in addition to that, you need X, Y, or Z. So we're setting the baseline, but I think we should refocus once we know what the practice areas are doing to make sure either if it's sufficient or does it need to be specified more.
I think we should discuss that, Linda, at our December 14th meeting. If you could put a little reminder in there, because I don't know at this point. I know that there is a strong position about having specialized training in domestic inter-partner violence, violence prevention, trauma-informed, trauma resilience, trauma responsive training, all of that. I just do, and I recall the position being annual training. I just don't know if it's in addition to the 30 hours. Because the 411 hour is part of the 30 hours, right? 4-hour legal ethics, competence, and bias. This is part of the 30, no?
Part of the 36.
Part of the 36.
That's how you make 36. Okay.
Right.
So, yeah, I don't know if we discussed that detail yet.
So the only thing about talking about this at the meeting, at the full meeting of the working group, is that other than the family law subcommittee, the other practice area subcommittees have not reconvened in a while. So it might be that what we say in the memo, in your recommendation memo, is that you're going to solicit input from the practice areas for for more detail on what should be required in that 30 hours. But I don't think it would be productive to have that discussion with the full working group, since the subcommittees haven't had a chance to
Okay. And like I said, we're meeting, family law is meeting, so we might as well, do our
Yeah.
work.
So I've done a draft of the licensing subcommittee memo, and we did add what was requested by the family law, and then say that we'll be seeking that kind of similar input from the other practice areas.
Okay, good.
I think that's perfect. And I think we should use family law as the example so that other practice areas will see what's being recommended by family law and consider doing something parallel. So Fariba, maybe you could raise it in the family law subgroup about, okay, we talked about that for initial licensure, but what about for continuing?
And I looked at the state bar rule. It's rule 3.114. That sets forth the education requirements for legal specialists. And there doesn't seem to be a cap on the number of self-study hours. It's interesting, subdivision C says the state bar may grant specialty education credit for education that meets certification requirements, as well as credit for MCLE requirements for legal ethics, elimination of bias, and competence issues. So it sounds like you can use some overlapping credits to meet your overall MCLA requirement as a lawyer.
Okay, so if that's true, then for lack of a better term, regular lawyers, non-specialized lawyers, my cap was what? Did you say 12?
12 and a half,
Okay, so,
the total.
okay, I would go with that. I think Amos, that's what you said too, yeah?
So 12 and a half, not half the total, right?
Right,
Is that-
right.
12 and-
Because there
12
is
and a half
no,
fine.
yeah.
So you want to be 12 and a half rather than 12?
Oh, no, whatever it is for. isn't
Okay,
it? Yeah.
all right. So, I think I understand that, in terms of what goes into the memo. So sorry,
We're making progress. We're going fast, but I do think that covers
right.
continuing education.
So the mandatory disclosures, I don't know. So those got posted to the website. I think both of you have had a chance to review it. I don't know if you want to sort of go into those in detail here, or if there's anything in particular that you want to call out.
So I think one of the things, if Greg, again, not to put you too much on the spot, but one of the things that I think we want to make clear in our report to the full working group is that we haven't yet decided exactly what language this is going to take or form it's going to take or where the rules go. And I don't know if we have preliminary thoughts about that, but I think the way it is right now, and the other thing is, this is without information about what the practice areas have decided exactly is going to be done. So of course, disclosures have to be flexible enough to be amended later to, make it clear what paraprofessionals can and can't do, and to figure out an easy way to doing that. So there's a lot of placeholders in this language, but I do think, I think one big question for me still is, I like it all in one place and clear, but if we follow the rules of professional conduct, there might be a bunch of different rules that are impacted by this. I'm not quite sure exactly, how that plays out. What do you think about that, Greg?
Well, I did have a chance to review these in more detail than last time, and I guess my more general comment, and then I think if we go through some of these, I do have some additional comments on specific requirements that are being contemplated. But I guess my general comment is really understanding in terms of where these, assuming you adopt these policy decisions that underlie these rules that you provided, Amos, the general question is where should they reside? And you touched on that. I mean, some of these rules really do read like professional conduct rules, disciplinary rules. And so that in the understanding the rules of professional conduct at rule 1.0 really sets forth the purpose of the rules, which is they're intended to regulate professional conduct of lawyers through discipline. So any violation of those rules can result in discipline. But there are other ways in which we regulate attorney conduct as well, through the Title IX rules or the rules of court, through the State Bar Act, different provisions. Some of the State Bar Act provisions, if you violate them, you may end up disciplined. But there are other ways in which we regulate attorneys. So for instance, when it comes to, and we talked about this last time, I think Business and Profession Code 6148, which requires a written fee agreement for services if it's contemplated that it's going to cost the client more than $1,000. The way we regulate attorneys who violate that is that we give the client the option of voiding the contract. And so a violation of 6148 doesn't necessarily result in discipline. Similarly, we were just talking about MCLE. If you don't comply with your MCLE requirement, you're not disciplined for it. You're placed on involuntary inactive status until you bring yourself into compliance, but that's not considered discipline, and we don't use a disciplinary machinery for that. So when we talk about the fee language that you proposed here, this of course reads like Rule 1.5 with some significant differences that I want to bring up later. But fees it's an interesting topic because we are one of the few states that do not discipline lawyers for charging unreasonable fees. They need to be unconscionable, and it's really based on case law. We made a decision years ago that we would not employ the disciplinary machinery to resolve fee disputes. So we take a two-tiered approach to fee disputes, because most of the cases in which an attorney was disciplined for the fee that they charged, there was some other element of overreaching involved, some element of fraud. And that really starts to touch on their fitness to practice and protecting the public from attorneys like that. So we adopted this unconscionable standard, and we have the factors set forth in the rules of professional conduct for that. But if there is no sign of that type of overreaching, the way we regulate attorney conduct in that regard is forcing them into mandatory fee arbitration if the client chooses to pursue that. And that really is just, it's one of those policy decisions that I wanted to bring up with the group that I talked about earlier, because this, the court passed on this policy decision only 2 years ago, when they decided to continue to employ the unconscionable standard for fees under the disciplinary rules. And so going back to your disclosures, going through them, I tried to pull apart what reads to me like a disciplinary standard and what reads to me like we're defining the scope of what is permissible practice by these paraprofessionals, and how are we going to regulate that conduct if they violate it. In some instances, it may result in discipline. In others, they may be, as I was saying with the MCLE situation, perhaps their license is rendered inactive for a period of time until they bring themselves into compliance. And I think that's kind of a fundamental question that we need, because a fundamental question we need to answer as we move through these things. So for instance, the disclosures in the written agreement, how do we want to discipline every paraprofessional that for some reason doesn't include one element that's required under the rule? Or do we want to regulate that conduct through some other means? And if it's through some other means, then that to me says that this is a kind of requirement that belongs in the rules of court rather than the rules of professional conduct. Does that make sense?
Very much so. It makes the job a little bit more difficult, but I think that makes a lot of sense, with the understanding that the court has made very clear what the purpose of the rules of professional conduct are for discipline. And the old rules weren't like that, right? So that was a change, and that's new. But
some of that's a good point, Amos. I think some people disagree, but the court did make a decision. The rules of professional conduct need to be standards that attorneys need to conform to or risk their license.
Right.
And so we moved away from language that was permissive in some way or smacked of like best practices, because we really didn't feel like first of all, it's too confusing. And one of the purposes of the rules of professional conduct is not only to discipline attorneys who violate them, but to to make it clear to attorneys what is the minimum standard we're expecting from you, and allow them to conform their conduct to that standard. And then we can deal with best practices through ethical opinions and other means.
So leaving fees aside for a second, because I think that is a difficult case with that framework. What about the requirement of a written agreement with certain disclosures? What does that strike you as the gist of that requirement? Is that a disciplinary, or is that more of a, just, rules of court type requirement?
Well, I mean, it strikes me as certain aspects of it when you for instance, if the person is holding themselves out as a lawyer, obviously that is a disciplinable offense, and we already have pre-existing rules. And I assume what we're going to be doing is looking at the rules of professional conduct for attorneys and determine, which ones should apply to paraprofessionals with very little changes, which ones need to be altered somewhat, so that we have a set of rules for paraprofessionals. And so in terms of telling them what they need to have in the contract, I think you can achieve a lot through cross-referencing to make it clear where if they're violating those standards under the rules of court, that it may lead to discipline through this other rule. Does that make sense? Okay.
So in other words, put them in the rules of court side, but cross-reference.
Right, and then decide if it's in the rules of court. Decide what is the result. What is the consequence if they fail to comply with this particular rule? Is that it similar to 6148? Is it that the client at their has the option of voiding the contract or not? Is it voidable?
So is one way to kind of decide on the ramifications of non-compliance is to see if it caused damage to the client versus they just didn't comply. So for example, let's say we required that they put in their contract that they don't have malpractice insurance. Let's just say that, right? And they just don't do that, but they do a good job for the client. I mean, how would we even find out, right? They do a good job for the client. Nobody gets hurt. They're just not complying with that portion of the rule. So is that one where it wouldn't have to result in discipline? And
Well,
it's just,
in that circumstance, Fariba, I mean, for lawyers, it would result in discipline.
it would.
You have a rule of professional conduct, rule 1.4.2, that requires them to make that disclosure if they do not carry malpractice insurance. So what you could still have in a rule of court, just so, and to Amos's earlier point, we want to make it very clear to these paraprofessionals what we expect from them. And so if we want to set forth these are the things that need to be in your written agreement. Some of those things are missing from your written agreement and they could result in discipline, then you would cross-reference to the rule of professional conduct. So to make it clear, this needs to be in your contract, and oh, by the way, if it's not, you may be subject to discipline, but the source of the authority for the discipline is the rules of professional conduct rather than the rules of
How do you choose, though, what will end up in I know, and that's a big question. What rationale do you use?
And that's the reason why I said early on that what might be helpful, a good approach is to come to some consensus on the underlying policy, what you want to and what requirements you want to impose on paraprofessionals, and whether or not, if they violate it, it should result in discipline or some other form of relief for the client or for the administration of justice, if we need to revoke their license for some period of time, or I'm sorry, put them in involuntary inactive status like we do with some attorneys when they violate certain standards. And then we can decide how exactly this is going to be shaped, because we're at the same time, we're looking at the rules of professional conduct and trying to decide, at least on a staff level before it's proposed to the larger group, these are the things that we should carry over that we impose on attorneys, and these are some additional requirements. So I think the way to do it is just to go through some of these things and start identifying what is the purpose of the requirement and what result do we want to have happen to somebody that doesn't comply, if that makes sense.
That's great. And I don't think we need to do that before the next working group, although if you want to do some of that now or do a little bit each time we meet for this, Happy to. I mean, I think fees in particular is going to be the difficult one, but some of these others still might be a challenge. I mean, informed consent. Where does that go? I don't know. I really like the idea of having a separate rule of court where all of this is contained, because one of the problems with the rules of professional conduct, no offense to anyone, is that it's a lot, right? And so you got to dig in these places, the rules come and cross-reference and deal with a lot of different stuff. And rule of court is effectively what they did in Washington State with their APR 28, where it's all contained in one place. And that's what these drafts are really based on. And then separately, there's the rules of professional conduct, which I assume track their attorney rules of professional conduct. And whether or not there's cross references, the structure is clean and simple to me. And at least paraprofessionals, triple LTs, can go and read those, and it's very clear and probably helps with compliance. But I don't have a strong, if there's a way to get to the same result, but there's a preference for where the rules are, I obviously am flexible.
And I'm assuming the rules of court process is simpler than the legislative process. It goes through judicial council, correct?
Well, no, the Title IX rules do not need to go through the judicial council process. So that the Title X rules do, and Title IX rules are really rules governing the admission and discipline of attorneys. And since the court has plenary authority in that area, we can adopt our own rules. Normally, the process that the court follows is they have the state bar recommend new rules. So, for instance, we just promulgated a new rule for provisional licensure for 2020 law school graduates. So there was a working group that went through a process of drafting the rule, and we had a public comment period following State Bar's own procedure, but none of that is actually required. The court also has adopted rules sua sponte when necessary. And I think since I've been with the court, we've done it at least 3 or 4 times in the Title IX area. So, and that's one thing to point out. I mean, it's similar to Washington. They're called APR rules because it's admission to practice rules.
Right.
And one of the ways they regulate, if you don't comply, you're not admitted to practice.
Right.
Or you lose your opportunity to continue practicing unless you come into compliance. Not necessarily discipline, but certainly it affects your ability to practice.
And
Yes.
we prefer that over legislating the Paraprofessional Act, California Paraprofessional Act, legislating, right? We prefer this because it's easier.
Well, it's easier, and it's probably more predictable in terms of the outcome.
Yeah, and some of these, I think for me, I like having bright lines. I mean, some of the issues with the rules of professional conduct is there's a standard generally, but to the extent, like for fees, as an example, or whether a disclosure is made or whether a informed consent form is used, the bright line makes it enforceable, makes it bright line easier. But I don't know if that means it should go one place versus another. I don't know.
Well, we do have bright line standards too in the rules of professional conduct, but they're written in a way of general application, and so it may not always be clear if you read 1.7. Most lawyers don't know how to apply the conflict of interest rules, and unless they're faced with particular factual scenarios, and then it becomes a little bit clearer. Right. We try to avoid that in the rules of professional conduct. So,
yeah, and the other thing I think might be, oh, sorry, go ahead.
Okay, you go ahead.
I was going to say, the other thing that I think might be helpful is generally, I think we're in agreement that we should use the rules of professional conduct, have the parallel. And what I'm really trying to do is identify where there are changes or something specific for paraprofessionals. And that could be done in a modified rule of professional conduct, or we could say that one doesn't apply. It's this rule of court, we can get to the same place. But I think our draft language, and this is what we should make clear in our report, I think these are, the ideas for how it should be regulated, but not necessarily the language or the form of the regulations.
Right.
Do you mind talking about fees for a minute? Because this is, Fariba and I have not talked about fees other than generally I have expressed my desire. I would like there to be like fee caps or bright line rules on fees. I think Fariba expressed that's not how it's done with attorneys, and frankly, other licensed professionals don't really have that. There are some exceptions, which we talked about before, where there are, you know, fee caps in terms of a percentage recovery or a contingency. I don't know, Linda, can you put up the draft language I sent around?
Yes,
Greg, it's
I'm
not
doing it now.
great. It's not a coincidence that this looks like it might track somewhat 1.5 because that's what I'm familiar with. But
Mhm.
very generally speaking, I don't like the unconscionability standard for paraprofessionals. I don't think it makes sense or fits, and most of the factors don't apply. I would like there to be, you know, this is what I thought might be a middle ground where there's a reasonableness, and one factor to consider of whether it's reasonable is if it's less than what attorneys charge. Because again, the whole idea is this is a lower cost alternative to attorneys. I do think, you know, I don't know if there's a good way to do this. So this is just trying to. So
Is that showing now? I can't.
it's showing, it's a little bit small.
Oh.
Wait, I think I can adjust that on my screen. Yeah, so Fariba, this is new for us. This is just a stab, but I think, so for attorneys are not allowed to make an agreement, charge, or collect an unconscionable or an illegal fee. So I added unreasonable or contingent. I think we're in agreement that there shouldn't be contingent fees. Is that right?
Well, definitely not for family law.
Yeah.
I have to tell you, I'm not familiar if for the other areas, for limited civil, is that allowed for attorneys? Contingent fees?
I guess. I don't see why not.
Okay.
It probably would be rare that an attorney would do that because of the
Is the amount?
limit on the amount. Yeah.
Mhm.
But I don't know that there's a rule prohibiting it.
Okay.
Yeah, so the issue would be, should a paraprofessional be able to share in the results, right? Get a percentage of recovery, and that raises concerns for me.
Right.
So I'm assuming that, and the tricky part here is the unreasonable part, because that is not, as Greg mentions, that's not a standard.
Yeah, how do you define that? Yeah.
And so what I tried to do that is in 4. So, but let's just go through it. So 2, I put flat fee, and this flat fee language is similar to the attorney flat fee, just moved around. And then I put that flat fees by paraprofessionals are encouraged. I think this is something, again, encouraged language might mean it's not appropriate for discipline or rules of conduct. So that might not be the language.
I think that's kind of going into the best practice sort of language that Greg said that they want to stay away from. Yeah.
Yeah. So, but my point is, I at least in general concept, flat fees, I think, are something that certainly should be allowed and maybe a best practice, right?
In family law, it would, well, they're doing it right now. And it works for certain cases for sure, especially the type that these paraprofessionals may be taking.
Okay. So again, this last sentence in 2, flat fees are encouraged, may not really belong if this is a rule of professional conduct, but that's sort of just my perspective, I guess. So contingent fee we can discuss, but for this draft, I assume we are not allowing it. And 4 is where the challenge, I think, for me is trying a middle ground. Rather than having a fee cap, a bright line fee cap, I tried to define what might be a reasonable fee. So take a look at that.
Just to go back to flat fees for a sec, I just want to make an observation. So the way the 1.5 was rewritten from its predecessor, in some ways, to really underscore for attorneys that a flat fee is essentially an advance fee, really, because especially if you're charging and collecting 100% of the flat fee at the initiation of representation. And so the rules of professional conduct really require lawyers to place that in their client trust account and only move proportions of the flat fee over to their operating account as earned. And so, and for violations of that, you can be disciplined. And probably the most disciplined rule, the rule that subjects attorneys to the discipline most often is Rule 1.5.
And it's difficult to decide how it's earned if there's no structure in the case. You
Well,
know,
they're required
$100 to find a summons and petition, $100 to file disclosures, you know, it's just really hard to.
Yeah, and they're required to account, and if there's any dispute, that the disputed amount needs to return to the client trust account until the dispute is resolved. And that again is an area that attorneys routinely violate that provision, and it can result in discipline.
Would it be, and I'm all for, you know, not creating too many special rules for paraprofessionals, but would it be unreasonable to ask that or have a rule that they only transfer it into their own account after the case is finalized or worked promise is performed?
It may be difficult. I think it's, well, it may be difficult to enforce, but it also, it may, I think the pre-existing rule is pretty protective. And they are required to account, as I said, to their client for everything that they have earned through their bills. And that's, I mean, I think there was a provision that is in 6148 regarding the types that what's required to be in the bills that are sent to clients.
Yeah.
And it was something I had made a note that whether or not you might want to adopt something like that, because 6148 does not apply to paraprofessionals if we were to license them. So there are aspects of 6148 that you might want to look at and carry over as well.
Okay.
Yeah, and I would say for Eva, my answer to that might be, that would be a best practice, right? If you want to stay clear of discipline, the safest thing to do is not take the fee until you're completed the work.
Yeah.
Flat
It
fees.
might cause financial hardship too. I mean,
Exactly.
they have a right to earn a living. I'm just putting this out there for discussion.
But I think it wouldn't be, there would be no discipline if somebody did that. That's the safe, best practice, safe harbor. But in reality, people, you know, need the money.
Right, right.
So, but what do you guys think about 4? Because this is where I tried to, rather than, again, I would prefer a bright line fee cap. But is something like this workable?
I could see some challenges in trying to determine what a reasonable rate prevailing in the community for similar work would be. And
But
how,
isn't that the objective standard for lodestar calculations?
so but is that something that would be published that the paraprofessional could refer to somewhere? What the,
No, so that's why I referred to the penal code section, because I do think there is a county level fee schedule. And again, it might not be directly applicable if it's a penal code, although there are some family law appointments of counsel. I couldn't find published in every jurisdiction what those rates are. It might be a more case-by-case determination of fees in certain counties. I think some counties have a schedule. But yeah, I'm looking for an objective. I'd much rather say, this is your cap. Look at those schedules, but I don't know if that would be, I heard significant pushback on something like that.
Can I suggest instead of low cost to say lower cost?
That's fine.
What do you think about that? Because low cost is, you know, very subjective. Whereas
Yeah,
low
so-
is implying it's lower than the cost of hiring an attorney.
Yeah, can anyone think of any other more objective standard than this? I pulled this really from the lodestar idea, which is when attorneys' fees are recovered under certain statutes, you know, you have to provide the number of hours and a fee, and it uses this sort of objective standard to say, the prevailing rate in the community by similar work, of similar work. And that could be specialized work, et cetera. So I tried to do two things. One is use that standard, but also say a factor to be considered is the fee schedules that courts use for appointing lawyers.
And Amos, what are you contemplating if a fee charged by a paraprofessional is deemed to be unreasonable based on this standard? What happens at that point?
So two different things is sort of where I'm coming from a policy point of view. From a policy point of view, I would like it to be enforceable that this is in fact a lower cost alternative. And what we've seen in some situations like immigrant consultants and other situations is people end up paying a lot of money, much more than they would if they engaged a lawyer, and not getting as good a quality of services. So I'd like there to be some way, either persuasively to let paraprofessionals know this is the purpose, you should consider this in setting your fee, but also on an enforcement side, whether that's discipline or it's not an enforceable fee. Again, I don't know how effective enforcement is if there's no bright line, right? If it's going to be effective enforcement, you need to have a bright line. So I don't know that this really gets you there. But at least it encourages, here's the purpose, consider this in setting, and maybe it'd be subject to discipline if you have somebody who's overcharging a lot of clients over time.
Yeah, I think it would go ahead. I'm sorry, Fariba.
That's okay. I didn't mean to interrupt. I was just going to say, I'm assuming this comes up when a client files a complaint that there's no fee police going around checking fees, right?
Well, we are going to have some affirmative proactive reporting as well. So although there might be able to hide it, we're probably going to ask what are the fees that you charge. But then, they may or may not be able to avoid.
Yeah, I'm just wondering what other methods of enforcement are there if it's not based on a complaint you receive from a client?
The other methods of enforcement for attorneys for unreasonable fees is either you can file civil action or you can compel the attorney into mandatory fee arbitration. And Linda, isn't the discipline subgroup going to recommend that there be a mandatory arbitration program for paraprofessionals similar to attorneys?
We haven't gotten that far.
Okay.
I think that is being, I think that there is discussion of including the paraprofessionals in the mandatory fee arbitration program. There definitely has been discussion. But I think there it was a way to reduce the burden on the discipline system because a lot of complaints essentially are fee disputes.
That's right. And that most of the accusations the court gets
Yes.
go to a fee dispute as well.
But regardless, is triggered by a complaint from a client. Is nobody at the state bar is doing some active checking, even if we're doing a reporting requirement, right? Is somebody going to go out there and check fees? No, it's going to be triggered by a client who submits a claim to the state bar or files a lawsuit or something like that, right?
Yes, I think that's right. I think the other policy here is some sort of bookends, right? I mean, if we have an idea of what these paraprofessionals are doing in certain practice areas, we probably could come up with a reasonable estimate of sort of what the full cost should be if it's in the thousands or tens of thousands per case. And my concern is, of significant overcharging happening. And again, I'm not sure a bright line fee cap would do it. I don't know if this does it or if this is a good middle ground.
It's going to be hard, honestly. That's why I'm having a hard time even commenting, because I can't grasp how in a family law case, which is, my forte, you would set it. Because first up, we're not setting income limitations, income qualification to people who can hire these paraprofessionals, right? People with houses and retirement plans and stocks and bonds can go hire a paraprofessional, as they do now too. So do we base it on a percentage of the total assets that are being divided, or, how do you base that? What if it starts out as a simple uncontested divorce and conflict develops and it turns into this high conflict case, that doesn't necessarily end up going to an attorney, right? So it's hard, at least in the family law arena, to put a cap. I kind of see your point, Amos, with regards to people who go to paraprofessionals theoretically are going there to take advantage of lower fees. And if the paraprofessional ends up charging more than an attorney would, then, I mean, that should be considered violation of a rule. But the thing is, how would the person know ahead of time that this case is not going to blow up to being a highly contested case?
But wouldn't that be solved by not putting a full cap on the total amount, but by capping in some way the hourly rate?
That would definitely, I'm talking more about flat fee sort of structure, but yeah, I mean, a paraprofessional shall not charge more than an attorney would, but then we have attorneys that charge at different ranges, and we have low bono attorneys that work for agencies that charge less. I don't know, when I was in practice, which is ages ago, I had on my own, I just charged a different rate depending on the person's income. I would cut them a break. So I'm not sure if I did that and a paraprofessional charges more, then they're not in compliance with this rule. So I'm having a hard time with this rule. Not I'm saying it's a bad thing. I'm just having a hard time.
And also,
so-
if you were going to discipline based on this, how are you going to determine what the prevailing rate for the work is? If it's because the rate for court-appointed counsel for indigent defense is very low. It's much lower than the prevailing rate for like family law attorneys. I'm thinking about in San Francisco. So the prevailing rate for family law attorneys is significantly higher than the prevailing rate even for people taking murder cases on the court-appointed counsel.
Mm-hmm. And
But then there's also like the Bar Association has a lawyer referral program that has a low fee panel. And so I think that the prevailing rate would potentially be subject to tremendous disagreement.
So do you think one of those rates that you mentioned, like the county bar, was it the county bar or the state bar?
The county bar doesn't set a rate. It just, there are attorneys who agree to charge a reduced fee, and there's no requirement about whether it's a 10% reduction or a 75% reduction. There is no requirement. So figuring out what the prevailing rate is, that in itself is a challenge. And I don't know that tying it to court-appointed conflict counsel, that's tied more than anything to the budget, the county budget.
Mhm.
And
Santa Clara County Bar Association Lawyer Referral Service has a modest means panel. And the last I knew, they were limited. If they wanted to be part of that panel, those attorneys could not charge more than $100 an hour. It didn't put a limit on the retainer. It didn't put a limit on the entire case, just hourly rate. Our county bar is a bit in trouble right now, but and I'm not sure $100 is still that rate. But can you imagine you're in Santa Clara County, $100 an hour, a new graduate out of law school, or just getting their license, starting practice, they charge $300 an hour. One last thing, minors counsel, as far as I know, if they're paid by the county and not the parents, I believe that's also that's either $70 or $100 an hour. Just letting you.
So does anyone have a suggestion for what might be an objective standard for somebody? And let's just say hypothetically, a family law paraprofessional, non-attorney, who is assisting someone fill out court forms and doing some of the other things that the practice group right now is considering that they may be able to do, to set it up as a lower cost alternative to hiring a lawyer that we could consider putting in as a standard. I mean, the other alternative is to set a dollar amount and to have that dollar amount be able to be moved by the board or the bar or the court, which I like very much, but I heard some reluctance. The other extreme is to not have any regulation about this and let the market decide. But again, with the idea of both consumer and public protection and for the whole purpose of this program is to have a lower cost alternative. So I think it would raise some concerns for a lot of people, including myself, if there was just no guidance or limitation on, the cost of a paraprofessional.
Is there any way to get some data? And I don't want to create more work for anybody, but to just see how many lawyer referral service modest means panel there are in California, and what is their rate cap
I might be able to track that down.
for those panels. And
Are you talking about for family law?
I think it's for anything. Most of their clients are family law clients, but I think they may have different specialties. Again, that's the information I'm looking
They're not just family law clients. And the thing with the modest means panel, and my experience is with the San Francisco Bar's lawyer referral service, the modest means panels, a lot of them, it includes a number of different people who join these panels. Sometimes it's lawyers who just want to offer reduced rate services. It also is an entryway. So lawyers who want to get some experience in the area in order to get on the full fee panel can take cases, these low fee cases.
True.
So I think I'm
can
not
look
sure
into
that
that.
referral services generally have a capped amount. I think most referral services, or at least the way it works in LA, I think is the largest, they don't set the fees that attorneys,
But
they
are you
set
talking
initial
about their modest
consultation.
means panel or their regular panel?
Talking about the
Well,
modest means.
Yeah, well, I think both. Well, modest means might be unique. I think
Yeah.
the court appointments, there often is a schedule, right? There is a schedule by county where, if you want to take one of these criminal cases, if you want to take a probate case, if you want to take a family law case, here's the rate per hour. That's why I thought that might be an objective standard, because that's going to change over time and could be something that we look to as a guidepost. But if you have other ideas, I mean, frankly, I'd be more comfortable with just a, schedule we create and that can be modified, and we set how it's modified.
I would suggest that
For each practice area and for each geographic region.
And we could decide if it needs to be, how it needs to be broken up. Yeah.
I would suggest that we stay away from court appointed, because that's a completely different standard. It's often much lower, like Linda said. And I think if we want to do anything, let's look at private counsel, such as lawyer referral service. Now, I just want to also clarify, Amos, our County Bar Association has a regular panel too. There's no limit on that at all. These are any experienced lawyer, any lawyer who just wants to be on the bar's referral list. Then we have a modest means panel, and attorneys who want to end up on that list have to agree to a free consultation and half an hour consultation and maximum $100 an hour, but no limitations on the amount of retainer they can charge. Yeah. So if we're going to use anything as a guide, I really do think we should stick with the private world rather than court appointed. That's just my input.
Okay. So do you agree that there should be some limit? Whether we can come up with an objective standard, but something that makes it clear that it should be lower than an attorney?
Honestly, I have to think about that. I think the language of this section is very advice-like rather than a rule. I'm just having trouble with it, and I would like to think about it before I comment.
Yeah, that's
because I just got it this afternoon. Honestly, things are crazy around here because of the new SIP. And I have to admit that I didn't have time to read it before I got on. My apology.
Yeah, no problem. I this is fair. I also think this is a hard one, right? So as far as other regulations, I don't know if you want to go through them a little bit more detail. I think a lot of it's going to come down to what we were talking about. We still have to go through and figure out, are these disciplinary rules as modifications to rules of professional conduct, or is it something separate? I don't know if there's particular ones you would like. Oh, you know what? I circulated a new one. I don't know, Fariba, if you had a chance to look at.
Are you talking about a draft scope of practice authorized by limited practice rule?
Yeah,
Yes,
that's the one that I posted to the agenda
Yeah.
today, the revised.
sorry, so so just to be clear, there were two changes since last time, right? There was the
Okay.
new one that I sent around just now, the one that's up, the
Mhm.
fees that we hadn't talked about at all. And then the scope of authorized practice, I added some language.
Okay,
Right.
yeah, I see you revised it on the fourth. Can you point out which parts? Because
Yeah.
we had agreed on the old version, so if, I think it's easy if I just look at what you added.
And I think I'm
Yeah.
sharing that now. Can you see
Oh,
that?
good. Let me,
Okay, very good, very good.
so I lost you guys. Let me see. Okay, you did it in red line. Perfect. So the red line, this also comes or is based on Washington rules related to triple LTs. They were just in a different place, so it didn't catch us for even when we looked.
Oh, I see. Okay.
But it's related. So I think you should, we haven't talked about this, but I
No,
think
I agree. No, this is great. I really don't have to take anyone's time. I think it's great. We see a lot of problems in this area, and I am a huge fan of this. I don't have to think about it.
And what I would say is that if you have a consensus on this as being an affirmative duty to inform, that
Mhm.
this probably would be a rule of professional conduct, specifically the counterpart for attorneys to Rule 1.4, which requires attorneys to communicate with a client regarding significant developments related to representation. This is a very specific significant development. And it might be helpful guidance to include and to set a standard, for paraprofessionals that in this instance, you must communicate this information, and failure to do so could result in discipline.
Thank you, 100%.
that makes a lot of sense. And do you think the same thing about the informed consent, or is that something different? Maybe we can take a look at that one.
Yeah, so I think in terms of making sure that they're providing informed consent, I do think some of these things are actually already covered in pre-existing rules. Some are not. And so it might be helpful to have a rule of court that requires them to include this as I imagine this is something that you would like to impose as a requirement at the initiation of representation,
Right.
as a separate writing. I had some questions between this rule and the written agreement rule. There seems to be some duplicative information that's included in both. One, I'm not a lawyer, is being included in both, and whether or not that's what you wanted to actually be in the written agreement as well, that they make that type of disclosure, or whether you would like it in a separate writing. And then in terms of the existence of any financial arrangements under the informed consent, such as referral fees, that will be covered under a rule of professional conduct as well. So this might be an opportunity for you to cross-reference to what will be the counterpart to Rule 1.5.1.
Okay.
Right.
Assuming that the group decides that they're going to allow for referral fees.
Exactly.
And the requirements under Rule 1.5.1 for attorneys is that you have to identify all the individuals receiving fees, that the actual terms of the division of the fees, that in an understandable language, and the paraprofessional has to agree that the total fee will not increase as a result of the fee splitting.
And it all has to be in writing, yes?
And it all has to be in writing. You have to get informed consent from the client under the rule of conduct.
So my sense was this is a hot button issue, and there's going to be a lot of viewpoints about fee sharing. We haven't talked about it, and I don't know if there's a reason to divert from what attorneys do or not. I think there was some concern about running and capping and this sort of stuff. And I don't know if you're comfortable walking us through that, or we should get some expertise to help us. But I don't know that I have a strong enough base of knowledge to know if there should be a difference for paraprofessionals and attorneys or not.
And I think we're kind of running up against the end time. We're actually about a minute over. So I'm wondering if what we should do for the memo to the working group with the recommendation and updates is to lay out, these are the recommendations that we would like you to vote on. These are the issues that we would like the working group to discuss. And we'd like your input, and here are the things that we're going to continue to develop. Does that make sense?
Yes.
Okay.
Yes.
I also
Right.
don't have a strong opinion about these drafts language that we have. If we want to combine them into one document, if we want to separate them into different documents, if we want to discuss in the report, the basis of them. I don't have a strong opinion, but I think it would be good to have them for the full working group to see.
Sure, and we can just include them as an attachment, and I think we probably should include them. It might make sense to just combine them into one document, that one attachment that says this is draft language that's been developed, and then have each one separately, and then discuss the policy issues and what's happening with the development of the rules.
And one of the threshold issues being, should there be two separate writings, one informed consent and one written agreement? And if so, what should be in the informed consent as opposed to the written agreement?
Right, yeah. All right. Well, I will use a lot of what you started, Amos, and I'll add as much as I can, and I'm sure I'm going to need to make a lot of revisions after I send it out to you.
Thank you, Amos. That's a lot of work on your part. Thank you.
Thank you very much.
Linda also.
Okay,
Great.
well, take care. Thank you.
Thank you, guys. Bye.
Bye.
Right.